You've just been hit by a semi, and now every insurance call feels like a trap. The truck driver swears it wasn't his fault. The company blames you. And meanwhile, you're the one sitting in the hospital questioning who's actually responsible when you didn't do anything wrong. In Florida, proving who's at fault isn't just paperwork. It decides who pays for your medical bills, your car, and your recovery. So what does it mean for a truck driver to be at fault in Florida? Hi, I'm Pablo Tamayo, an attorney that's been practicing in Florida for approximately 2 decades. And so let's start here. When you're in a truck accident, figuring out the truck driver was at fault means you're trying to see if their actions or their mistakes caused the accident. In Florida, fault matters because it decides who's responsible for your injuries and who pays for your damages. We all share the road, but truck drivers have an even bigger responsibility because big trucks can cause big damage. So how does Florida law look at fault? The state uses something called modified comparative negligence, and this just means more than one person can share the blame. But if the injured party is found to be more than 50% at fault, then you, as the injured party, can't recover any damages at all. For you watching this, that means just because the truck hit you, it's not automatic that the driver will be solely found at fault. You'll need to gather evidence and facts to show what really happened. Let's dig into how you can determine if the truck driver is at fault after your accident. Negligence is a fancy word for carelessness. If the truck driver was negligent, meaning they acted carelessly or violated the rules of the road, they can be at fault. Now here's what you should look for. Did the truck driver run a red light? Were they speeding? Were they tailgating? Or maybe even making an illegal turn or an illegal lane change? In Florida, breaking any traffic law is a big red flag. For example, if the police report says the truck driver ran a stop sign, that's a good start to showing that the truck driver's at fault. But truck drivers actually had extra rules that they need to follow. They can't drive for more than a certain number of hours without a break because driving tired can be just as dangerous as drunk driving. There are rules about how much weight trucks can carry, how often they can be inspected. If the driver skipped their required rest, overloaded, and/or failed to follow required trailer inspections, then those can all be signs of negligence. Was the driver texting, eating, or even talking on the phone at the time of the crash? Even worse, was he under the influence of alcohol or drugs? If you spot any clues of distracted or impaired driving, that's a strong case for fault and should be noted to the police officer at the scene so it can be documented. What if a tire blows out, the brakes failed, the lights didn't work, or maybe because the driver or the company skipped regular truck maintenance? In Florida, both the driver and the company have to keep trucks in a safe condition. Lack of maintenance can point to fault. So let's make it simple. If the truck driver did something that they shouldn't have done or didn't do what they were supposed to do, they might be at fault. This is why you need to collect as many details as possible at the scene: photos, notes, witnesses' names. After any truck accident in Florida, the most important thing you can do is gather evidence. Why? Because evidence tells the story of whose actions caused the crash. Here are the types of evidence that help show the truck driver was at fault. Always call the police after a crash. The responding officer will write an official report that could list who they think caused the accident. If the truck driver was ticketed for a traffic violation, that's a good start. If you're able, use your phone to take pictures, videos, everything you can to document the accident scene. The truck, the road, any skid marks, your vehicle, your injuries. Sometimes nearby businesses or traffic cameras can have footage of the accident. These visuals can prove who did what, and it can be valuable evidence. People who saw the crash are also valuable. Ask for their names, contact info. Third-party witnesses can confirm whether the truck ran a light, swerved, or was driving carelessly. Modern trucks also have black boxes, just like an airplane. These track the speed, the braking, how long the drivers had been on the road, among other things. If the logs show the driver didn't take the required breaks, was speeding, that may be evidence of negligence as well. So sometimes a history of past accidents or violations can show a pattern for the driver. Your attorney can help you get that important information as well. Was the truck in good condition? Missing or delayed maintenance records can prove the driver or the driving company skipped important safety steps. A real Florida example for you. We had a client who was rear-ended by a semi on I-95. The truck driver swore he was driving the speed limit and he was paying well good attention. But our team got the black box data and discovered he was driving over the speed limit and hadn't taken a rest in the required amount of time. Combined with witness statements, the evidence made it clear. The truck driver was the one at fault, not our client. Now, when is the trucking company also at fault? This is a question I get all the time. In Florida, it's not just the driver who could be responsible. Many times, the trucking company can also be at fault, even if they weren't behind the wheel. Why? Because the company has a legal duty to hire safe drivers, to train them, and to make sure that their trucks are being operated by safe drivers. Here's when a trucking company is often considered at fault. Negligent hiring. The company hired someone with a bad driving record or no proper license, and that driver caused your accident. The company may be on the hook. Poor training. Truck drivers need special training to handle these giant vehicles and their trailers. If the company sent a rookie out on the road without the right training and the right experience, that could be negligence. Pushing drivers to break the rules. Some companies pressure drivers to skip their rest breaks or fudge their logbooks to meet delivery deadlines. If a driver caused your accident after being pushed too hard, that's on the company too. Skipping maintenance. If the company failed to fix the brakes, the tires, or other safety systems, and you're hurt because of it, the company may be held responsible as well. So, if you're in a trucking accident, never assume it's just the driver's fault. In many cases, the company is equally responsible, or even more so than the driver. And what happens if you're partly at fault in Florida? Well, here's the part that surprises people. Florida's modified comparative negligence rule means that even if you're partially at fault, you can still recover some money for your injuries, as long as you're not mostly at fault, greater than 50%. So, let's say you were changing lanes and the truck driver was speeding. The insurance company might argue that you share some, if not all of the blame for the improper lane change. Let's say you're found 30% at fault at trial and your damages are $100,000. Well, you could still recover $70,000. But if you're more than 50% at fault, in Florida, you can't collect any damages from the other side. This makes proving the driver's fault even more important because every percent counts. What should you do right after the accident to help hold the at-fault party accountable? If you were just in a Florida truck accident and you suspect the driver is at fault, or you know they're at fault, here's what you need to do right away. Call 911. Get medical help for anyone hurt, and make sure you present the facts to the responding law enforcement officer, as he will write an accident report reflecting all the accumulated evidence of fault that he has on the scene. Take photos of the vehicles, license plate, road conditions, injuries. The more, the better. Get witness information, names, numbers, written statements if possible. Your attorney can help with that. Get the truck driver's info, full name, driver's license, insurance details, very important. And the company they work for, also very important. And don't admit fault. Be polite, but don't guess what happened or apologize for something that wasn't your fault. Just give the facts. See a doctor. Even if you aren't catastrophically injured, seek a medical evaluation for your injuries. Injuries can show up later. Medical records are very important proof for your injuries in your case. And of course, contact an attorney. A Florida truck accident attorney can help gather evidence, talk to witnesses, get black box data, and handle tricky insurance companies while you recover from your injuries. So here's another real case Florida example. Was the truck driver at fault? Let me tell you about a recent case. Maria, a nurse from Tampa. She was sideswiped by a box truck merging into the highway. The truck driver said Maria was speeding. Maria was sure she was going the speed limit and not speeding. The police weren't sure who to believe. We got the truck's black box, and we saw that the driver hadn't made a signal into the lane. And guess what? He was going over the speed limit as well. Thanks to all this evidence, we proved the truck driver, he was at fault. And Maria got a great settlement to compensate her for her injuries and other damages, including her medical bills and her lost wages, etc. So, why is proving fault so important in Florida truck accidents? If you don't prove the truck driver was at fault, the insurance company has every excuse to pay you less or nothing at all. If you can show the truck driver or their company, if you can show they were at fault, you unlock the door to getting fully paid for your medical bills, your lost paychecks, your pain and suffering, even future medical care if you need the compensation you deserve. That's why everything we've talked about matters so much. To answer your question, how do I know if the truck driver was at fault after my truck accident in Florida? Look for signs of negligence, like breaking traffic laws or skipping required breaks. Gather solid evidence, like police reports, witness statements, and know that sometimes the trucking company is just as responsible as the driver. If you do your part after the accident and work with a trusted attorney, you give yourself the best shot at proving fault and getting the compensation you deserve when the accident was not your fault. Don't stop here. The next video is a must-watch. 3 ways companies can be forced to pay you after a truck accident. This one will show you how to actually get the money you're owed, even when the insurance companies don't want to pay. It's packed with tips that could make all the difference for your case. Click right now so you don't miss out on protecting your rights. I'll see you over there.